this field of law is the tool that is used by the international community to prevent and prosecute the most serious crimes, the crimes that shock the conscience of humanity. To quote the expression that is used in the Rome Statute, which is the treaty on the basis of which the International Criminal Court was created. So international crimes, they violate the core values of the international community that include peace, security, well-being of the world, and they often overlap with the most serious human rights violations. And the provisions of the Rome Statute identify 4 international crimes, which are genocide, crimes against humanity, war crimes, and the crime of aggression. And we will talk a little bit about them during this lecture. And these are the crimes over which the ICC can have jurisdiction. So the main question that has been raised over the last years and was raised by scholars especially was whether ecocide can be considered and recognized as a 5th international crime. And if so, how it can be recognized as such. And with the term ecocide, which I mean more or less everyone here is familiar, ecocide means the killing of the environment, because it comes from this prefix eco and the suffix side that comes from the Latin cedo, which means killing. So basically it literally translates into the killing of the environment. With respect to whether ecocide can be considered as a 5th international crime, I would say that it is very likely that such a recognition will happen at some point in the near future. At the moment, ecocide is not, the environmental protection is not the focus of international criminal law norms, but it has been the focus and it will likely be. It has been because in the past, I will move to the first slide. During the negotiations of the draft code of crimes against peace and security of mankind, the issue of environmental protection through international criminal law was raised and debated. Indeed, the International Law Commission considered including serious environmental crimes among the crimes against peace and security of mankind. And Article 26 that you can see in the slides I'm sharing was drafted entitled Willful and Severe Damage to the Environment. And according to this article, the environmental damage that should be caused by willfully by an individual should be widespread, long-term, and severe damage. But then in 1996, the working group that was working on the Code of Crimes Against Peace and Security of Mankind reviewed the definition that we have just mentioned of Article 26 and suggested adding a part to the second version of Article 26, according to which an individual who willfully causes widespread, long-term, and severe damage to the natural environment that should also cause a grave prejudice to the health and survival of a population. So as you can see, we have 2 different definitions of ecocide that were discussed in the past in the context of international criminal law. The first definition is more ecocentric because it protects the environment as such, while the second definition that we are looking at also considers the damages to human beings. So basically, this definition protects the environment as a habitat for human beings and not only as such. But in the end, Article 26 was removed from the draft code of crimes against peace and humanity. And the working group that was working on that decided to include this provision as part of the war crimes. And this provision is what indeed we have in Article 8 of the Rome Statute. So moving at the current scope of international criminal law norms, I just said at the beginning of the presentation that nowadays environmental protection is not considered in international criminal law norms, but there is one exception, and this article is that exception. As you can see, the article repeats the three requirements of widespread, long-term, and severe damage to the natural environment that should be caused during an attack that is intentionally launched by an individual. So we have already two important challenges in the application of this article. The first challenge is to prove that the harm to the environment is widespread, long-term, and severe. So we have a high threshold of gravity of the harm, which was also used in Article 26. And then we have another important challenge, which is the need to prove that the individual was launching the attack intentionally. And intention is a mens rea that is quite high. Another challenge concerns the application of this article, and it is that this article only applies to international armed conflicts. But as you can guess, this kind of damages that are very serious damages to the environment can also be committed in the context of non-international armed conflicts or in peacetime. And with respect to these two scenarios, NIACs, non-international armed conflicts, and peacetime damages to the environment, nothing is said in the Rome Statute. There are no provisions that deal with these two different situations. So we can definitely say that nowadays there is an evident gap in the Rome Statute concerning environmental crimes committed during NIACs and peacetime. However, it should be pointed out that in the al-Bashir case, the prosecutor of the ICC sought to prosecute the then president of Sudan, Omar al-Bashir, for genocide on the grounds that he was involved in the contamination of wells and water pumps. In the second warrant of arrest that was issued by the pretrial chamber 1 in July 2020, it was stated that there are also reasonable grounds, and I quote, to believe that in furtherance of a genocidal policy, the government of Sudan forces throughout the Darfur region in Sudan contaminated the wells and water pumps of the towns and villages primarily inhabited by members of some groups that they attacked. So the problem here with respect to this case is that the first and second arrest warrants against Omar al-Bashir were not implemented because al-Bashir is still at large. He has not been arrested and transferred to the seat of the ICC, the International Criminal Court in The Hague, which means that his case remains at large, at the pretrial stage, because the ICC does not have jurisdiction to try individuals in absentia. So this is the current situation. Only one provision with respect to international armed conflicts and no provisions with respect to non-international armed conflicts and damages to the environment committed in peacetime, but a reference to environmental damages in the Omar al-Bashir case. And as I said at the beginning of the lecture, environmental protection most likely will be the focus of international criminal law norms. But then the question becomes how it can become such a focus. And two proposals have been made at the moment. The first one is the one of that concerns the crime of ecocide. The first one is introducing ecocide as a fifth international crime. And the second one, the second one is that of relying on existing international crimes to also address environmental damages. So with respect to the first proposal, that of introducing ecocide as a fifth international crime, we can say that nowadays there is a growing number of scholars, of NGOs, and even human rights bodies that are pushing for this big step for the recognition of ecocide as an international crime. And with respect to states, we can speak of a veritable wave of criminalization of ecocide. Very recently, on February 22, Belgium has adopted a law with respect to ecocide and became the first European country to recognize ecocide as both a national and international crime. And with this provision on ecocide, Belgium tries to prevent and punish the most severe cases of environmental degradation, such as extensive oil spills, that can be attributed to individuals in the highest positions of decision-making power and to corporations. So this is a very big step. And this follows an agreement that has been reached in November 2023, so quite recently, by the European Union to incorporate a new offense into the Environmental Crimes Directive, targeting specifically cases comparable to ecocide. And the definition that is included in this law adopted by Belgium relies upon a definition of ecocide that we will see in a minute, and that has been drafted by the independent expert panel of the Stop Ecocide Foundation, so by an NGO. And with respect to this, growing number of scholars, NGOs, and human rights bodies that are pushing for recognizing ecocide as a fifth international crime, we can also mention the Council of Europe, because more or less 1 year ago, it adopted a resolution 2477 that is titled Environmental Protection in Armed Conflicts, and in which the Council of Europe, recommended a number of solutions to fill in the gap related to environmental protection in international instruments. And among these solutions mentioned the need to recognize ecocide as a national and international crime. So there is an agreement with respect to the need to have this crime. But the problem comes when we need to define the concept of ecocide. And several definitions of ecocide have been suggested over the years. The first time that the term ecocide was used was in the context of the Conference on War and National Responsibility in Washington, D.C. It was used by an American biologist, Arthur Galston, to define the catastrophic environmental impact of the use of the herbicide Agent Orange in the Vietnam War. And this incident was also mentioned on Monday during the lecture held by Ambassador Jacobson. But then this concept re-emerged in 2010 when Polly Higgins, an English lawyer and activist, suggested amending the Rome Statute in order to include this definition of ecocide that you can see in the slides, which is different from the ones we have seen so far. She states that ecocide is the extensive loss, damage, or destruction of ecosystems of a given territory to such an extent that peaceful enjoyment by the inhabitants of the territory has been or will be severely diminished. So as you can see, we have another approach, which is anthropocentric again. So the environment is protected to the extent that the peaceful enjoyment by the inhabitants is not diminished. And other definitions have been since proposed. For instance, the one that has been used by Belgium as a basis to write the law on ecocide, which was drafted by the Stop Ecocide Foundation in 2021, according to which ecocide is the unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment. So here we have still another definition of an ecocide. We have another type of mens rea, of mental element, and the three requirements of severe, widespread, and long-term damage are reduced. So the threshold of gravity of this ecocide is lowered down because we need the severity, but either the widespread nature or the long-term nature of the damage. And actually, we can spend hours talking about definitions of ecocide, but I don't want to waste so much time on this, but this is just one to let you understand how many positions there are at the moment in this respect. And I would like to mention briefly other three definitions that have been suggested by scholars. So we have seen NGOs, states, and also scholars intervened in this debate on the notion of ecocide. And Dominic Oates, for example, in a very interesting paper that he wrote on the concept of ecocide, adopted a particular definition of ecocide that follows the definition of crimes against humanity. Basically, if you look at Article 7 of the Rome Statute, you can see that there is a chapeau, like an introductory paragraph, that describes the context in which a list of crimes can be committed to amount to crimes against humanity. And he did the same with respect to ecocide. He defined this chapeau, this introductory paragraph, and then made a list of environmental crimes that, if committed as part of a widespread or systematic attack directed against the environment, can amount to ecocide. So I found this definition particularly effective because it differs from the others that we have seen so far and replicates the same reasoning that is behind the definition of crimes against humanity. There is also this definition by Adán Nieto Martín, according to which an ecocide is the systematic attack to environment that causes permanent, serious, and widespread. So we have the three elements again: harm, or the death or illness, permanent and serious, to the civilian population. So basically, in this definition, the attack to the environment is seen as having two different causes: either the harm to the environment or the harm to the civilian population that lives in that territory that is attacked. So this definition, I think it's interesting because combines at the same time the ecocentric and the anthropocentric approach to the protection of the environment. And Adán Nieto Martín also suggested drafting and adopting a convention, an international convention on the concept of, on the crime of ecocide, in order to make this crime imprescriptible as the other international crimes. So I think this is also important to highlight. And then we have this definition that was proposed by Matthew Gillett, which is quite similar to the one we have seen before, that has an introductory paragraph and then a list of crimes. And again, here we have the choice in between widespread or long-term. So what we can conclude from this is that one of the main challenges of finding a definition of ecocide is finding an agreement on the constituent elements of this crime, which does not exist at the moment. As you have seen, there are different definitions, different interpretations of what ecocide is. So the first step should be really to understand what we mean as the mental element of ecocide, what we mean as the contextual elements of ecocide, etc. But apart from these technicalities, these legal aspects that might be a challenge into the for the inclusion of ecocide as a fifth international crime, there is also another challenge, which is more practical and maybe more political. Because if we want to include ecocide in the Rome Statute, we need the consent of the states parties to the Rome Statute. And we need a high consent. We need 2/3 majority, according to Article 121. So this is another problem, because the inclusion of ecocide into the Rome Statute, I do believe, can provoke two different consequences. It might generate a positive consequence, which is that of accelerate the national wave of criminalization of ecocide that I was talking about before in the state parties to the Rome Statute, because those states will be obliged to conform their laws, their domestic laws, to the content of the Rome Statute, if they do not oppose so. And the second negative consequence might be that the inclusion of ecocide in the Rome Statute might result into fragmentation of the states parties of the Rome Statute, because there might be some of them that do want to integrate the Rome Statute provisions with ecocide, and other states parties that decide not to recognize this crime as a fifth international crime, but they may continue being parties to the Rome Statute. And there might be also the option of states that withdraw from the Rome Statute for this reason, but I hope that this scenario will not happen. So this is the first proposal, that of including ecocide, and we have seen that there are many challenges with respect to the definition, with respect to the inclusion in the Rome Statute, but there are, at least there is an active debate with respect to this crime. And the second proposal would be that of relying on existing international crimes that are under the jurisdiction of the ICC at the moment. So genocide, crimes against humanity. And the first, of course, remark in this respect is that if we rely on ecocide, we rely on a crime that let us protect the environment as such. But if we choose to rely on other categories of crimes, such as genocide and crimes against humanity, we, yes, can protect the environment, but in an indirect form, so indirectly. Because in this last scenario, the environment would be protected when serious damage to it would result in the destruction in whole or in part of a population, or in severe suffering or injury to members of a civilian population against whom an attack was primarily directed. So it would be more limited, the scope of application, the scope of protection of the environment, if we rely on genocide and crimes against humanity, for instance. And there has been an explicit mention, actually, to the prosecutor of the ICC willingness to investigate environmental harm related to international crimes already in the 2016 policy paper on case selection and prioritization. But this lecture is particularly timely because just some weeks ago, I think, the prosecutor of the ICC, Karim Khan, launched a public consultation on a new policy initiative to advance accountability for environmental crimes under the Rome Statute. So this is a big step forward into the direction of a major protection and increased protection of the environment in the context of international criminal law. And this policy will deal with crimes within the jurisdiction of the ICC committed by means of or that result in environmental damage. So basically, this policy, as far as I understood, will rely more on the second proposal we talked about. So relying on existing international crimes to protect the environment in the context of international criminal law. And I would like to use just the last minutes of this presentation to talk about the Ukrainian-Russian conflict. Because I think that everybody, and especially our dear participants from Ukraine, they heard about the destruction of the Kakhovka Dam in June 2023. This dam provided water for the Kakhovka hydroelectric power plant. And immediately after the incident, the Ukrainian investigators started gathering evidence in order to accuse Russia of causing extensive flooding and environmental damages by destroying the Kakhovka Dam. As a result of this incident, dozens of people were killed and many villages were submerged by flood. Billions of living organisms were killed also suddenly. And the International Criminal Court opened an investigation with respect to the Kakhovka Dam. But as we can see, as we have said during this lecture, the ICC cannot rely on the concept of ecocide in order to address this problem, because ecocide is not part of the material jurisdiction of the ICC. But the ICC can maybe consider this situation as a war crime case. It can decide, for instance, the prosecutor to rely on the Article 8.2b4 that we have seen before of the Rome Statute, that explicitly mentions widespread, severe, and long-term damage to the environment in the context of an international armed conflict, which is the one between Ukraine and Russia. The problem might be the high gravity threshold that the prosecutor needs to prove, and at the same time, the intent of the perpetrator to launch an attack. According to some scholars, the prosecutor might also rely on other war crimes. For instance, war crime that is prohibited in Article 8.2b2 of the Rome Statute, which prohibits attacks on civilian objects, and the Kakhovka Dam can be considered as a civilian object. Other scholars have suggested using the article that prohibits starvation as a method of warfare by depriving, civilians of objects that are indispensable to their survival. Also, crimes against humanity might be considered an option. For instance, forced displacement, other inhuman acts, murder as a crime against humanity. And with respect to ecocide, as I said, the ICC cannot rely on an article on ecocide at the moment, but the Ukraine can. I'm sorry. And this is why after the incident, the Ukrainian prosecutor opened a major investigation into the destruction of the Kakhovka Dam into war crimes and ecocide on the basis of Article 441 that you can see in the slides, and which provides another definition of ecocide if we compare it to the ones we have seen so far. So this is just to say that there are different, of course, options to address environmental damages that are at the moment currently occurring in Ukraine. And I would also like to say that this conference is really timely because there is another news that is coming from the ICC. And 2 days ago, the pretrial chamber 2 has issued warrants of arrest against the 2 individuals, Sergei Ivanovich Kobylash and Viktor Nikolaevich Sokolov, in the context of the Ukrainian situation for alleged crimes committed during the missile strikes that the Russian forces under their command were launching against the Ukrainian electric infrastructure from October 2022 until March 2023. This means, of course, that the destruction of the Kakhovka Dam is not under under the scope of these arrest warrants, because it was committed in June 2023. But this investigation on crimes committed against the Ukrainian electric infrastructure, we can think it might be relevant for the case on the destruction of the Kakhovka Dam, because the primarily goal of the destruction of the dam was the hydroelectric power plant. So let's see what would be the result of these arrest warrants. And to conclude, I would like to emphasize, because I think we're running out of time, that both the proposals we discussed today, so that of relying on the notion of ecocide as a fifth international crime, and that of relying on international crimes to protect the environment, which seems what the OTP of the ICC is doing at the moment, both of them can coexist. It does not mean that if we rely on ecocide, we cannot protect the environment by relying on crimes against humanity or genocide. But of course, the legal good that is protected by the provisions is different. So if we want to protect the environment as such in international criminal law, ecocide should be qualified as a fifth international crime. Thank you very much for your attention.